Okay, well, good afternoon, everyone. I am so excited to be here with you all this afternoon so that we can explore the school to prison pipeline. My name is Lachelle Stroud. I am the lead magistrate in domestic relations and juvenile court right here in Franklin County, Columbus, Ohio. Um, I graduated from OSU Law School back in 2003. So I've been a practicing attorney for the last 17 years. During my years of practice, I've been in both the public and private sectors. As a public sector attorney, I've had the opportunity to try bench trials, jury trials, argue before the Court of Appeals, as well as the Ohio Supreme Court, um, and also practice in domestic relations and juvenile court, representing both families and children on the domestic relations side and the juvenile side. I've had the opportunity to be a guardian ad litem for children, and guardian ad litems are attorneys who are appointed by the court to do independent investigations and represent back to the court what's in the best interest of the child so that we can save the child from enduring the additional trauma of coming to court. The types of cases that I hear on a daily basis are abuse, neglect, dependency cases, where I have to determine if a child has been abused or neglected by their parents, or their parents allowed for that abuse to take place, and then determine if that child should be removed from his or her home and given either to a relative or to Children's Services custody, and then what the parents need to do to get the child back in the home so that we can reunify the family. On the juvenile side, we handle delinquency cases. And delinquency cases for a magistrate would be any type of case from an unruly, which we call status offense, all the way up to the felony cases. So magistrates are appointed to the bench to serve as judicial officers. In a county like Franklin County, there are too many cases for the judges to be able to hear all of those cases. So the judges appoint magistrates to hear the cases and to make the determinations. And then the judges adopt the decision of the magistrate to make it final. So it's like another level of an appeal for the parties who come before us. So on delinquency cases, that could be anything from misdemeanors to felony cases. And the judges on the delinquency side handle the bind over cases, which would be the types of cases to determine if a youth should be tried as an adult, if they should be bound over to the adult system. We also have specialty dockets in domestic relations and juvenile court. One of the specialty dockets that I preside over is called the empowerment docket, and that's a dedicated docket for youth who are victims of human trafficking. And we provide them the necessary resources and support so that they could come out of the human trafficking lifestyle in a safe manner, and then give them resources so that hopefully they don't return back to that lifestyle. So that's just a little bit about me. I'm from Columbus, Ohio, born and raised. It's always been my dream to be an attorney since I was 5 years old. I'm a strong advocate for justice and making sure that we have equity in the justice system, and that people have adequate representation. So that's what led me to this field. And like I said, I've been practicing for the last 17 years. So I'll just jump right in. Wanted to give you all a little bit of background about myself so you could know a little bit about me. I went to OSU for law school, like I said, and this is that time. Right now, I am here. I'm very excited to be with you all to talk about school to prison pipeline, juvenile justice, if any you have, please put it in the chat area, and I'll try to answer questions throughout the presentation, and then also leave 15 minutes at the end so that we can have discussion as well. I'm really in this area, please feel free to ask any questions. And if I'm able to, I will answer your questions so that we can just have a great dialogue on this issue. So we'll get right into it. All right, so the school to prison pipeline, what is it and how did we get here? So from a historical standpoint, the founding fathers of our country said that offenders, the whole goal was rehabilitation. So the court system, when it comes to juvenile court, was supposed to be about compassion, fairness, and rehabilitation. The goal of juvenile court was never intended to be for punishment, but instead to rehabilitate. And then we see a shift in the 1970s, 80s, and 90s to where we start to see language with people saying that nothing is working. We've tried rehabilitation, nothing works. Comes to juveniles. You start that juveniles becoming more dangerous and fearful of you, and that leads to activities. And that's when we start to hear the phrase super predator. Again, was to say and becoming more wide. So you start to see a shift in issues. I'll try to turn off Are you able to hear me now? Okay. You said a bit better. Let's see. Is that better without the video? Okay, it's better now. All right, I will leave the video off. Do I need to go back to the introduction? I won't go back to my introduction. I will just continue now without the video. Hopefully that's helpful. We'll go through, and then if I need to share anything else about my introduction, we can do that at the end. So I apologize, I'm not sure what happened. So I'll just go back one slide just to make sure that you all could hear that. So I was really just sharing about the shift that came in the 1970s and 80s with the narrative that nothing was working when it came to rehabilitating youth. And then that's when we saw the juvenile super predator phrase come into play, and that we needed to be tough on crime, and that there was a shift in legislation as it relates to juvenile laws to say that we needed tougher penalties for juveniles. So the outcomes of being tough on crime is where we started to see the disproportionate impact when it came to our prison population. So the United States is a leader of imprisoning its population, especially when it comes to the people of color. So African Americans make up 13% of the US population. However, in the United States, the prison population is 40% African Americans. And then when you go to Franklin County Domestic Relations and Juvenile Court, you see 78% of the population that comes before us in Domestic Relations and Juvenile Court are African Americans. Which is in no way reflective of our population. And then when you look at our detention center, which we now call the Juvenile Intervention Center, it fluctuates anywhere between 90%, and then when you go to African American males, at times it's as high as 95% of the population in our juvenile detention center right here in Franklin County. And so what we have found over time is that punishment does not have a lasting effect on changing the behavior of the youth. So if we're saying that we want to rehabilitate, the things that we're doing, historically speaking, we're not rehabilitating youth at all. So when you label youth to be at risk, we found that it has become more detrimental and that the practices are ineffective at best. Studies have shown that one night outside of the home, whether it's one night in foster care or one night in the detention center, drastically reduces a youth's chance of graduating from high school. So a youth staying in the detention center just for one night drops their chances of graduating from high school by 50%. And it looks like I see a hand up. Okay, maybe if you could put your question in the chat box, and then I can answer the question that way with the person who had your hand up. And furthermore, we found that punishment and supervision alone has never been found to reduce recidivism. So what is the school to prison pipeline? The school to prison pipeline is a process by which students are pushed out of schools and pushed into prison, or pushed into the court system, whether prison or the detention center. Some of the outcomes we've seen from the school to prison pipeline is that, one, it criminalizes youth. And then secondly, after we have criminalized the youth, what we're finding is that those same youth have been labeled as being difficult to educate. And that, once they're suspended or expelled from school, then it's difficult for them to find another school to go to. Some of the policies in the schools are what are putting these labels on youth, like the zero tolerance policies in the schools. Their disciplinary policies within the schools are making this label on youth to where it's making them seem more like criminals as opposed to as children. And moving the children from the educational environment and saying that the juvenile or the criminal justice system is the better place for them as opposed to school. Okay. Is the sound better? I just saw the chat where the sound was breaking up again. Okay. Hopefully it's better. We'll keep going. Okay, so the one example that I wanted to share was like a school fight. So I know when I was in school, if someone were to get in a fight, generally the school, there would be a punishment, whether it be an in-school suspension, or whether it be detention or study hall, or you have to miss recess or miss a field trip. What we're seeing is if there's a school fight or even a food fight in the cafeteria, in addition to whatever the punishment is at school, we're also seeing charges filed in juvenile court. So I oftentimes have youth on my docket where they got in a fight at school. Both of the youth were charged in the offense, both with one count of assault, two separate court cases. And just because of the time that it takes to come to court, sometimes it's 6 to 12 months later. And they're both before me, each charged with misdemeanor assault. It could be that sometimes they're back friends again, perhaps don't even know why we're fighting in the first place, because again, they're in middle or high school. And then it could be that one was already suspended from school for a week or 2 weeks, and the other person could then expelled and now at a totally different school. Now they're in front of me and I have to determine, one, who was the aggressor, and then two, what should the punishment be? And oftentimes I tell the youth that come in front of me, whenever it's already been a punishment at school, that there's really nothing from my standpoint. Could I remove them from home? Yes. Could I order them to do time in the detention center? Yes. Am I going to do any of those things? No. And from my standpoint, they have already suffered the most by having that time outside of school. if they've been suspended or expelled or have had to switch schools because of a fight at school. And the same thing for food fights. But because of the shift historically to where youth have been deemed to be these super predators or to be increasingly violent, you're starting to see more charges filed based on behavior in the school, which is from the school to prison pipeline. By having, oftentimes by having the school resource officers, sometimes we're seeing more harsh discipline in the school, as well as those charges in addition to whatever the sanctions were in school. We're seeing more school-based arrest. And like I talked about earlier, the students being deemed difficult to educate. Because once they get in a fight at school, that goes into their educational record as well as their juvenile record. One of the common misconceptions of juvenile court is that your juvenile record will automatically disappear once you become 18. And that is not the case at all. You can have a record in juvenile court, and unless the judge or magistrate expunges the record at the end of that court case, you have to apply later for your record to be expunged. So it is not something that happens automatically. And what also happens is that once you have that juvenile record, if the record is not expunged, if you do grow up, your brain is developed and you become more mature, if you end up making a mistake as an adult, your juvenile record is viewed by the judge in adult court and could give you increased sanctions or punishment in adult court. So we have a question. The question is, are schools the ones that decide the level of punishment for children being disciplined? Is this done school by school? So the first part of the question, are schools the ones that decide the level of punishment for children being disciplined? So the schools determine what the sanction is going to be at the particular school. The school says that they want to do in-school suspension. If based on a zero tolerance policy at that school, that's been determined by the school board. If they're going to have a zero tolerance policy and the student is expelled, the school determines whatever the punishment is at the school. And it's also the school that determines if they're going to refer the case to the prosecutor's office to determine if charges will be filed in juvenile court. Once it gets to that point, then it's up to the magistrate or the judge to make a determination in court. So the school makes its own sanction, punishments, determinations, but then that child can have a case filed for the same actions that the school has already punished the child for. That same incident can be filed in court, and then it's up to the court, and the school does not have any say in what the outcome is. We will see sometimes where the school employees are subpoenaed, like if it's a school fight and the teachers witness the fight. Teachers could be subpoenaed to come to court and testify, and would absolutely, as judicial officers, hear from the teachers, but it comes down to the judicial officer making the determination. And this is done school by school. So yes, it's up to the school whether or not they're going to contact the police department to have the case investigated to see if the allegations will be filed as a case by the prosecutor's office. So that comes down to if the school contacts the police department. If there's a school resource officer that's already housed in that school, then it makes it easier because you already have a resource officer who's there, present and able to assist with the filing of that report. Okay, so now let's talk about Franklin County. We talked historically just in the United States overall, but let's talk just a little bit about Franklin County and some of the things that we see here when it comes to the numbers. So we went back to 2008 and just did a snapshot of 10 years from 2008 to 2018. So unruly offenses are offenses where the parent is filing the action against the child, saying that the child is not following the rules of home, like frequently running away, not going to school. And then we also saw a change in the law during this time period, school truancy cases. So when the allegations are that the youth is not going to school, those were delinquency cases in the years that are on this chart. Now that's in the top category for unruly. So if you combine unruly and delinquency cases together, those are all of the cases where if the offense was charged against an adult, it would be a crime. So those are like juvenile criminal cases, the first two categories. The third category is the abuse, neglect, dependency, where it's really against parents, saying that the parents have abused or neglected the child. So what you see going back to 2008, where the numbers were lower for abuse, neglect, dependent cases, where the charges in the complaint are against the parents, those numbers are lower, and the top two categories are higher. And that means that the case is filed against the juvenile. And then if you look 10 years later, because of all of the information I shared earlier in the presentation, where we started to see the research that we weren't really helping juveniles like we were supposed to, and that we did not see a decrease in recidivism, that's when you see the top two categories start to decrease and that bottom category increase. Because some of the cases, let me see. Are we still having sound issues? Okay, let me see. Are we still having sound issues? Or should I dial in? I'm sorry. Okay, you said it sounds a little bit staticky. Let me see if I can get the phone number from my email to dial in. I'm not sure. I use Zoom all day long for hearings, but for some reason this evening we're having issues. I'm just pulling up my email so that I can go in and get the phone number to dial in.
Followed by pound. Enter your participant ID followed by pound. Otherwise, just press pound to continue. Please enter the meeting password followed by pound. You have joined the meeting as an attendee and muted throughout the meeting.
Okay. Okay. Hopefully this is better. Okay. Okay. Are you all able to hear me? All right. Okay. All right. Let me go back to the screen share. I apologize. Hopefully you all were able to hear, and we will just keep going. All right. So we were getting into the numbers for Franklin County. So this diagram just shows those delinquency cases going back to where you see that drastic decline in cases. So let's just jump into the cases by race. And let's just focus on the 2019 numbers on the far right column in this pie chart.
So of the total delinquency cases that we have right here in Franklin County, you see that 73% of the cases are against African American youth, whereas 5% are in the other category and 22% are white youth. Then when we go to the next slide, you see that this slide breaks it down by race as well as gender. So on the far right, again, these are cases from 2019. You see that 60% of the youth of the cases that we had filed against juveniles in Franklin County in 2019. So that's 3,144 of the cases where it was against a youth male of color. And when it comes to youth females of color, that was 18%. When we look at the white youth who are in Franklin County Juvenile Court, you see 16% are white males, whereas 6% of the cases that we have are white females. Which begs the question, why are the numbers as high as they are when it comes to youth of color? Right? Because we know that this is not at all reflective of the population in Franklin County, but this goes back to multiple things, like the school to prison pipeline that we talked about earlier. It could be where there's more cases that are coming out of the schools to where they already have a higher population of youth of color in those schools, and perhaps some of the other schools that have a higher population of white youth, perhaps they're not having charges filed in addition to what the sanctions are in the schools. So some of the things that we're doing in juvenile court to try to combat these disproportionate outcomes, we are in Franklin County what you call a JDAI court. JDAI stands for Juvenile Detention Alternatives Initiative, which the objective of JDAI is to combat the disproportionate outcomes that you saw on those last few slides, and to eliminate inappropriate or unnecessary use of secure detention. And we want to redirect the finances and also try to improve the conditions in secure facilities. So we want to make sure that the youth who are in the facilities have good conditions, and that we're only holding youth that need to be in detention. We don't want to mix low and high level youth together, because what we see is that when youth who are low risk are mixed in with youth who are higher risk, some of those behaviors start to rub off on the youth that are low risk, and they start to pick up some of those negative behaviors just from spending time with other high risk youth. The studies have showed us, since we became a JDAI court, that most youth will grow out of delinquent behavior without any type of orders from a court or without any type of intervention. So if we all think about ourselves, everyone who's participating this evening, either you all are medical students or professors or people in the community that want to participate, and most of you have completed, secondary education. If you think back to yourself and the types of behaviors that you engaged in when you were younger, none of us are perfect, but if you think back to some of those things, there are some behaviors that you yourself grew out of, most of us without any interaction with the court. So when we look at that, if our goal is to rehabilitate and not to harm you, we need to keep these things in mind when we're making our decisions and our outcome, because the goal of JDAI is to avoid further trauma to the youth that we serve. And we're only to detain if that youth is going to be a serious threat to the community or to himself or herself. So some of the alternatives and things that we do when it comes to sanctions are do nothing at all. If a case comes in front of me, and let's just say it's a school case where there was a school fight, and I'm able to see that the school handled the situation. Perhaps the two people are friends. It could have just been a misunderstanding. I have the discretion to do nothing at all when it comes to sanctions, and I could dismiss the case or just close the case out. Another alternative is diversion. We have diversion programs in the court to where youth can be linked with services, they can be referred for community service, and we can do all of these things outside of a courtroom without causing additional trauma to the youth. Another thing that we try to do is to look at high risk versus high need. So when we look at the youth, is the youth before us in court because the youth poses a high risk to the community, or is it that the youth is a high need youth and maybe they just need resources as opposed to need any type of involvement with the court? When we see that we have a high need youth, one of the things that we can do is refer that youth for an assessment. One of the top assessments that we use is called a behavioral health assessment, or a BHJJ. So this slide that I'm sharing right now, we use this as a diversion program, and these are some of the numbers that you'll see. So when we refer a youth between the ages of 10 and 18, if it's a mental health assessment or substance abuse issue that we have, instead of holding that youth in detention, no matter how they got to us, whether it was from a case referred from school or a case referred from the community, if it's a high need youth, we can refer them for an assessment. So from 2016 to 2018, we referred 544 youth for a BHJJ assessment. The average age was 16 years of age, 79% were male, and 70% were non-white. Which again, going back to the earlier slide, you're still seeing that we have a disproportionate number of youth of color that come before us. What we found from the mental health assessments were that 36% of the females talked about suicide, and 15% shared with the evaluator that she had attempted suicide at least once. So all of these youth in this assessment were all court-involved youth. The majority of the youth had a history of mental health and substance abuse issues in their family. And some of the common diagnoses that we saw were cannabis disorders, conduct disorders, ODD, and depressive disorders. Nearly 70% of the youth completed treatment successfully. So these could be youth that I refer for an assessment, and that's the only order where they just have to comply with the assessment and then comply with the recommendations from the assessment. So 70% completed those recommendations successfully. The BHJJ assessment led to 69% reduction in risk for out-of-home placement, and the youth reported significant reductions in trauma symptoms and substance abuse. The majority of the youth, their grades improved in school, suspensions and expulsions were greatly reduced, and over 93% of the youth were not sent to ODYS, which is the Ohio Department of Youth Services, after they completed the recommendations. Let's see. Let's go back to the PowerPoint, but I thought that would be helpful to share here so that you all could see some of the outcomes in our BHJJ assessment. So my judicial philosophy, this goes to, things that we're trying to do, things that I'm trying to do as a judicial officer. So my number one goal in the cases that I preside over is to do no harm. Similar to the goals in the medical field, right? We don't want to do any harm to the people that come in front of us. One of the philosophies that I use on a daily basis is the My Child philosophy. So when a child comes in front of me, when I'm trying to determine what type of disposition or sentence that I'm going to give, I view the child through the lens that the child that's in front of me is my own child. Because studies have shown if you view the child as your own child, then your outcomes are different. It's not like you're viewing someone who you could see through the lens of a super predator or someone who's dangerous. When it comes to your child, you're going to, just like in the medical field, you'll give the top care. You always do, but it's just a different lens when it's your own child. And for myself, I know, my child may make mistakes. And the first time my child makes a mistake, I'm not going to automatically jump to the most and the more harsh penalty. I'm going to give my child another chance and maybe look at what other things I can do to help. I also made a shift in my own courtroom by asking questions. And my first question is, what happened to you versus what did you do? So again, just trying to determine, is this youth someone who is high needs versus high risk? I only remove children from the home when it comes to children's services, if I find that reasonable efforts have been made to avoid the removal, and I try to keep the child in the home with his or her parents as often as possible and only make those removals if it's unavoidable. And then when it comes to the delinquency side, I'll only hold or detain a youth if that youth is a serious threat to the community or to himself or herself. So what are some of the things that we can do collectively when it comes to confronting the school to prison pipeline? So as a community, we can start to ask more questions. So ask questions about the policies in the schools. So challenge. If your school does have a zero tolerance policy, like most schools do, what's the policy at your school if a youth is involved in a fight? Is it automatically a call to the school resource officer or a call to law enforcement? Or will the school try to handle as much as possible in-house if the school is going to make their own punishment? And then when it comes to the policies, ask questions like, are the policies evidence-based? Or are they based on stereotypes, or are the policies rooted in systemic racism? So just looking in to see what types of policies your school has. So some of my final thoughts are, number one, just to let kids be kids. Again, we've seen through the research that most youth are going to grow out of delinquent behavior without any type of intervention. So if we let kids be kids, we know that their brains are underdeveloped at this time, and we know that they're going to grow out of these things, so we don't need to necessarily intervene and jump to harsh penalties because we know that children are not a threat. Since our court over the last 10 years has been a JDAI court, as you saw on the slides in the beginning, we've actually seen the numbers decrease. So if you look back, we've been a JDAI court since 2009, and you see from this chart how the number of filings has drastically decreased as opposed to increasing. When we became a JDAI court, people feared that we would start to see crime go up because youth were no longer being held in the detention center in the numbers that we were seeing early on. When I first came to the court 7 years ago, our juvenile detention center was overcrowded to the point where youth were sleeping on cots in the gym. And now that we're a JDAI court and we've been since 2009, you see that we are drastically under the population when it comes to our juvenile detention center population because we're no longer going right to holding a youth in the detention center now that we're JDAI, but we're making sure that we're only holding those serious offenders as opposed to holding youth for low level and low risk issues. And then the other thought is that it takes effort and open minds for all of us to achieve any type of change. And just like we all have to work together and put in effort and keep an open mind to achieve change in the community, we need to do the same thing when it comes to the juvenile justice system. And I strongly believe that if we work together and if we make informed decisions, we can effectuate change and start to see a difference in some of these outcomes and the disproportionality when it comes to juvenile court. So, are there any questions? I can also go back and answer any questions that you all might have from either the PowerPoint or anything that you were unable to hear in the beginning when we were having those technical difficulties. And it looks like someone wanted to see the slide as well. Okay. The question is, what is the curriculum for this program? So this is a slideshow that I developed. This is just a slideshow that I developed using the data that I had from our court. So the information that you saw in the beginning, all of these numbers were based on Franklin County Juvenile Court. And I put these things together based on the committees that I serve on our court. We routinely go back and look at the data so that we can see if we are making changes. And we try to make sure that in the court committees that I'm on, that quarterly we go back and look at these numbers to see if there's a change when it comes to race and when it comes to sex as well, just like on the next slide. So that's what I used to come up with this. Let's see, how do you follow up on the children who do not complete the assessment? So if a child does not complete the assessment, then Nationwide Children's Hospital is who we use for the BHJJ assessment. So if a child does not complete the assessment, then we at the court receive a letter back from Nationwide Children's Hospital to tell us that the youth did not comply with the assessment. And then it's up to myself, if the case is assigned to me, or up to one of my colleagues to determine what we're going to do. Sometimes it could be, I'm going to share my video so I can see you all. Sometimes it could be that it was, they didn't have the appropriate contact information. So I might refer them again for another BHJJ, or it could be that the youth didn't have transportation. So we just go back and ask questions to figure out why they did not comply with the assessment. And then really we have the discretion of whether we want to dismiss the case or if we want to proceed more formally and make other types of decisions as opposed to referring them for that assessment. But really the assessment gives the youth an opportunity to get resources so that we can help the family if that's what the issue is, if they really are high needs family. Are there any other questions? Let's see. What do you see as being the next steps our community needs to take to further address these disparities? Is there anything you feel we should be doing other than putting pressure on our schools to handle behavioral issues differently? So what can we do? I say one, as a community, again, making sure that you're asking your schools and holding your school officials accountable when it comes to things like the school to prison pipeline, finding out what are the school system's view, whether it be like the Board of Education or if it's a private school, going to that board or going to the principal to find out what their thoughts are on the school to prison pipeline and what types of things they're going to do. So really, you know, just asking questions to see, for instance, if there's a school fight at your school, will you handle that in-house or do you contact law enforcement? No. And then asking the school officials what their thoughts are on the school to prison pipeline. Another thing that we can do is make sure that we hold our community leaders accountable. So making sure that when it comes to who our local officials are, who are our local officials so that we know what types of policies that they're putting in place. Because when you go back to the juvenile predator, the super predator model, that came from our own governmental officials. And then there was legislation that was put in place to make sure that there were more harsher penalties on juveniles. So it's making sure that we have accountability across the board in the school, as well as our legislatures, as well as the judges and the people who are going to make the determination to make sure that everyone all across the board is being held accountable, because the outcomes that we see are because of the decisions that are being made, not just in the school systems, but also in the court system and the General Assembly as well. What are your thoughts on school districts moving to disband their relationship with local police departments and replacing them with social workers, et cetera? As I shared earlier, which hopefully, I'm not sure what the sound was like at that point. So right now I'm a magistrate in the court, so I'm an appointed judicial officer, and then judges are elected judicial officers. So as a magistrate or a judge, as a judicial officer, I'm unable to give opinions on issues like, SROs, what are my opinions? I can only share the facts, but it's very important as a judicial officer that I remain unbiased, fair, and neutral, because I would never want anyone to be able to question if I had a case in front of me with an SRO to say you took this stance on this date, say that you were against SROs or that you were for SROs. So I have to maintain my position of being neutral, impartial, and unbiased. So what I will say is that that is a very hot topic, especially in the times in which we find ourselves. So I will share that I've always been a champion for racial justice and one to fight to ensure that we have equity across the board. And the criminal justice system is no different from any other system, to where we've seen the long-term effects of systemic racism. But I think, again, that's for all of us to make sure that we're holding all officials accountable, that people know who your judges are. When you're going to vote, make sure that you know who your elected officials are when you're going to vote, and researching the decisions that they've made. So it's important to make sure, one, that we're all registered to vote, two, that we're all researching who we're voting for, because those elected officials are really the ones who are going to make the decisions when it comes to things like combating the school to prison pipeline. It's the local officials across the board who are making those decisions. So making sure that we're researching what their decisions look like. And then three, that there's representation at every level, ensuring that we have representation, not just for the community in which we serve, but representation based on the types of cases that are coming before that particular court. So that to make sure that you have more people who are going to use that my child philosophy when it comes to judging cases, and not just someone who doesn't understand the types of cases or the type of people that come into the courtroom. What I will share with you all is that in juvenile court, when it comes to those delinquency cases that we talked about earlier, one of the highest zip codes that we see here in Franklin County is 43211. And then one of the second highest zip codes that we see, oftentimes it goes between 43213 and 43219. And it's not that those zip codes are necessarily higher in crime per se. It could have to do with the law enforcement being in those areas. And I will say, I grew up in 43211, and now I live in 43219. And I share that all the time with the youth who come into my courtroom, because when they see me, because of the numbers that you saw earlier, they see someone who looks like them. So I think it's important to make sure that our judicial officers represent the community that we're serving, so that one, the youth can see themselves, and then two, so that they can be inspired to know that you don't have to be a product of your society, and that it really is possible to do and to be more than what you're seeing sometimes on a day-to-day basis, and that your zip code should not determine your level of success. Just like your zip code really should not determine whether you go to juvenile court or not, just like your school should not determine if you're one of the ones who come into juvenile court. One of the top offenses that we see has to do with school truancy. And usually that shocks people who are not familiar with court, because they feel like, again, because of the narrative, that youth are more and more dangerous. So when people ask what's the top offense that comes before us, they're not prepared to hear that oftentimes the highest offense is school truancy, which is youth not going to school. And I've had cases where it's a school truancy case and the child is 6 years old. If you think about that, should the child be in court at 6 years old for not going to school? Is that more about the child, or is that about the parent? And sometimes I go all the way up to when they're teenagers and say, at what age should we shift the blame for a child not going to school from the child's responsibility to the parent's responsibility? Because if a child's first contact with juvenile court has to do with that child not going to school at the age of 6, the studies have showed that once you come to juvenile court, you're more inclined to continue to come to juvenile court. So if I keep those cases as opposed to dismissing those cases or putting the onus on the parent, then that child, just from being in court and being exposed to the trauma of coming to court and having orders made against that child could continue to come to court, because then you see it started out as a school truancy issue. But then because you're so used to coming to court and conditioned to come to court and maybe start to believe the narrative yourself, then you actually could pick up criminal cases and it go from school truancy to assault because you were at school and got in a fight. But maybe it was because you missed school and then you start to get frustrated being at school, and then you receive this label that you're difficult to educate, so then you start to act out, which is why we need more things like assessments to see, is this child acting out because of high need versus is this child acting out because the child is high risk. I can talk about that forever, because I really do believe that when it comes to school truancy, that should be on the parents, and that we should work together as a community and as judicial officers, the community keeping us accountable as judicial officers to make sure that we are not going for the school to prison pipeline, and that we're not, as the judicial officers, believing the narrative that juveniles are dangerous. So there was a question about my future plans for this work and my career. So what I shared earlier, again, I'm not sure about the sound, but I've been practicing law for 17 years with the overwhelming majority of my experience being in domestic relations and family court, because I strongly believe that families should be kept together whenever it's safe to do so and given the necessary resources and support. So I've dedicated my life's work as far as my professional career to working in this court. I've been a magistrate making decisions as an appointed judicial officer for the last 7 years, and there's now a newly created seat in domestic relations and juvenile court. So I'm actually running for judge this year in 2020 to make sure that our court continues down the path that we're on right now to combat systemic racism, the school to prison pipeline, making sure that we have progressive policies and make sure that we stay on the right track that we're on to keep those numbers down and work harder to fight against the disproportionate numbers that we see in juvenile court when it comes to the youth that come before us. Because I think we all as a court see that there's something wrong with 78% of our population being African Americans that are coming into domestic relations and juvenile court, since that does not reflect Franklin County at large. Let's see, are there more questions? Please share how medical students may be involved in mentoring youth in the juvenile justice system. So we have what we call the restorative justice circles, which you can go on our website, which is, I'll try to type it in the chat and type at the same time. So FCCOURTS.org. So that's franklincountycourts.org. Then if you click on domestic relations and juvenile court, you can go to our diversion programs and find out about our restorative justice circles, where those are members of the community who are committed to working with juveniles and they mentor youth. So that's one way that you can get involved. We also have, we used to call it the probation department, but now we call it community enrichment services, where we have mentors. One of the most popular orders that I make is when I order youth to write a life plan. So one, I try not to do anything at all, knowing that most youth are going to mature out of delinquency behavior. Second, I try to divert the youth so that they don't have to come into the courtroom at all. But if I do have one of those serious cases to where it really is high risk, one of the orders that I make is to have the youth write a life plan, because studies have shown people who write out goals and have goals are less likely to engage in delinquent behaviors. I've known since I was 5 years old, I wanted to be a lawyer, and I believe that's one of the many reasons why I did not necessarily end up in the courtroom, because I always knew at the forefront of my mind that in order to be a lawyer, it would make it more difficult for me if I had a juvenile court record. And I believe that if youth have their goals and they have them written out, they'll be less likely to engage in delinquent behaviors. And when I have the youth write out a life plan, I always ask them, what is their future career goal? And then I try to match up youth. Because again, you can be inspired if you see someone, especially someone who looks like you, doing what you want to do. So our community enrichment, formerly known as probation, oftentimes will match up the youth with mentors. So perhaps if you reach out to the court and you say you want to be engaged as a mentor, then it could be a youth who also sees himself or herself in the future as being in the medical field, so that you can have that match when it comes to mentoring youth, so that they can see someone and know that it really is possible to achieve their goal. Does parental education take place as well? Yes, we do. So if the BHJJ makes a recommendation for in-home counseling, family counseling, we call it MST, to where it's more intensive home-based counseling, then the counselors come into the home and they work with both the youth and the parent to help them increase their skills, whether it be communication or just helping the parent to better parent the child, as well as providing resources. Because what we see, some of the youth that engage in the behaviors that they engage in, it's again because of their needs. I've had students youth that come in front of me like for theft charges. And when I talk to ask, what happened, I may have had a youth who went into Walmart and stole t-shirts because their parents didn't have the money to buy them underclothes. So is it right to do that? No. But in asking those questions and engaging with the youth, I'm able to find out really they're just high needs. So what can we as the court do to get them resources and support so that they don't have to go out and steal things, but let's help the parents and see what the issues are so that we can help the parent become more of a support system for the child. And let's see, I think there was one more. Has the implementation of JDAI increased student school attendance / graduation rates in Franklin County? We have seen an increase in attendance, both from JDAI as well as the BHJJ results, where we've seen that students' grades have drastically increased, as well as their attendance in school. Honestly, I don't have overall graduation rates, but we do know that we've seen improvements in the classroom. So the time is now 5 o'clock. I want to be obedient to the time and my assignment. I really enjoyed being with you all. I apologize. I'm not sure why we were having those issues. I Zoom all day long now for hearings, but I apologize for the technical difficulties we were having in the beginning. Again, my name is Lachelle Stroud. I shared with the students earlier, I will continue to be a resource, whatever it is that you all need from us. Please continue to stay engaged, stay involved, and let's all work together collectively as a community to make sure that we're fighting against systemic racism, fighting against the school to prison pipeline where necessary, and fighting against these disproportionate outcomes that we're seeing in juvenile court. So again, thank you all very much for your time. I greatly appreciate you all having me, and please feel free to reach out to me if you have any questions in the future. But take care, and I wish all of you nothing but the best and success in your futures. Thank you.